Welcome to our family business in conflict webinar today. So let's get started. Okay, a bit of housekeeping first, if I may. We are recording the session today. I anticipate it will go onto the Mills Reeve website and will go out via LinkedIn. But don't worry, we can't see any of you, so please don't worry about that. When the webinar ends, a pop-up should appear on your screen so you can send us some feedback on how well we've done. Please be as brutal as you wish, but also to provide some intel in terms of what other topics you'd like us to cover in the future. The Q&A function is also enabled on this webinar, so you can send us questions. We'll try and get through some of those at the end of the webinar, but if not, please do follow up with us afterwards. Send us an email and we'll be only too delighted to answer any questions and to make contact with you. So let me introduce our panel of speakers today, hailing from 4 different Mills Reeve offices and 4 different legal disciplines. I'll start with Tom first. Tom Amarnani is from our Birmingham corporate team, and he has a particular focus and expertise in the tech sector. Rebecca Cockerill hails from our Norwich office. Rebecca is from our employment sector and represents commercial companies, mostly for employers. Ellie Milner is a partner in our Leeds team, acting predominantly for business owners. She also has the very concisely named STEP Advanced qualification in advising the family business. So is well qualified to be on our panel today. Katherine Kennedy heads up our family team in Birmingham. She's a DR dispute resolution specialist, as well as litigator, and like Ellie and myself, represents business owners predominantly. And last but not least, me. I am a member of the family team in Manchester. I'm a dispute resolution specialist, mediator, collaborative lawyer. I co-lead the family subsector for Mills Reeve and chair the SME group in the Manchester office as well. So we're talking about family businesses in conflict today. So we need a family, we need a business, and we need some conflict. So I'm going to introduce our case study relatively quickly. Hopefully it was sent out via email as well, and you've had a chance to look at it, but if not, please don't worry. So our family, Mike and Caroline Brown, they're in their early 50s. They married in 2001 and they've got 2 children. Simon, he's 20 and he's engaged to Jess, and Amber, 17, who is still at school and has aspirations to be a vet. Now, Mike is from farming stock, the family farm being in Oxfordshire, which happens to be where we've just opened our 7th office, if you haven't clocked that line. And he and his brother Brian, when they were 18, were gifted 100 acres of land each, and they decided to farm it together under the M&B Brown Farms partnership. And a common theme that you'll see in our case study today is this a great lack of documentation and formal in relation to their business enterprises. Mike saw a corner of the market which actually they weren't exploiting that much, which was to sell veg boxes to the consumer directly. So he opens a farm shop farm and sells farm partnership produce as well as from other local suppliers. They don't have any contracts, it's all very informal. Now the company is set up by Mike's school friend who has a legal practice in the village, and at incorporation, Mike is the sole shareholder and director. Standard articles of association, and again, very little other documentation is put in place. He then meets the lovely Caroline and all falls into place, and he wants her to be part of the business and makes her a 50% shareholder, director and employee, which is something we see on a regular basis in our cases. And again, there's no shareholders agreement put in place apart from the appointments company's house. Caroline focuses on Mike's Veg Boxes Limited while Mike concentrates on the farming partnership, and she takes it online. Who doesn't want a box of broccoli on their doorstep when they come back from a day at work? Company turnover rockets, employee numbers increase, and they're doing very well indeed. And Simon and Jess join the business as well, but there's no employment contracts for anyone working in with the business, includes non-family members. So it all starts to go wrong. In January 2020, Mike and Caroline separate. They haven't got a pre or post nuptial agreement in place. So there's no pre-agreements around how they would approach certain classes of assets, such as the farms or businesses. And the hostility builds up between the two of them through that frustration, and that spills out into the workplace, and employees are caught in the crossfire as that separation is played out at work. Caroline shows that she's not quite as interested in the business as she was previously, so Mike decides to terminate her employment, but can't remove her as a director and a shareholder, which is something we'll cover during our discussions today, I'm sure. Simon steps up and says, right, I'm going to step into my mum's shoes and run the business, but what's in it for me, Dad? And he wants some shareholding or some of this incentivization to be involved. Another headache for the family is Amber, who wants to lead a non-farming future, is really worried that if she doesn't go down that path, she'll miss out on some of her inheritance. And there's a few other issues just to finish, which are going to compound the issue for Mike and Caroline. And the first is that Caroline has set up in competition. So she's now got her own veg box business underway, and she's managed to convince some of those Mike Veg Box Limited suppliers to follow her, which provides supply issues for Mike's company. And that's all while Caroline is still a shareholder and director of Mike's Veg Boxes Limited. Mike's father's recently died, so Mike and Brian are about to inherit further land and assets. And unfortunately, Brian's health has deteriorated, and he now lacks some mental capacity to make decisions for himself. So I'm going to stop sharing my screen, and hopefully you'll be able to see everyone anyway. And let's kickstart by going to you, Rebecca. So from your perspective and an employment lawyer view, what sort of issues have we got in play here, and what could the company have done to avoid some of these issues?
Well, I think the main challenge here, which isn't uncommon, is that the individuals are relying on the goodwill of the family, and so haven't put in place clear documentation, probably aren't strictly following employment law requirements, and they're relying on family members not bringing claims, and also that everyone just understands what the arrangement is without actually documenting, which is all well and good. But obviously it can create issues. In one circumstance, if you're ever looking to sell a business, any potential purchaser would expect to see clear documentation in place for employment contracts, so everyone knows what the terms are, and also evidence that you have been following employment law legislation, or, as is the case here, more commonly when relationships break down and suddenly that goodwill is gone, and then disputes start arising. So we deal with Caroline's termination first. So in that, if you read the details before, there was no process followed. She was just terminated without any reason, and that leaves the business open to unfair dismissal claims. Also, because there was no contract in place, there's going to be disputes around holiday pay, notice pay, things like that. And also, slightly more tenuous, but there is the potential for marital discrimination. So you can be discriminated against because you are married. So it's an untested area in this kind of scenario, but you could see a situation where she might try and say, part of the reason I was dismissed is because I was married to Mike. Also, we've got the descriptions of the hostile work environment and employees potentially being caught in the crossfire. So you're at risk there of grievances and potentially constructive unfair dismissal claims coming up. And you can imagine for Simon and Jess, it's probably not a very nice environment at the moment to be working in. So that creates its own issues as well.
If I'm right in thinking, Rebecca, as well, there could be some health and safety breaches if it's at a level. I remember I had a case years ago where a wife was walking through the office block with a crowbar, basically taking her everything into her own hands, and she wanted some documentation out of a filing cabinet, which she was very being open. However, the risk was the employees might have felt that they were put at risk in that scenario. Is that something which might be relevant
Yeah,
here?
I mean, definitely. But if it reaches that point of animosity, you've got a duty of care to your employees, and need to be taking steps to ensure that they're not put at risk by crowbars or anything else. But I think another point, obviously, is that Caroline started up in competition, which is always a massive risk for any kind of employees when they leave, if they've got a knowledge of the business. And here you've got maybe some bad feeling as well going on. And if you'd had a contract in place, there is potentially scope there for including post-termination restrictions. They are quite hard to enforce, but there is the potential there that you could have then potentially done something about it, though obviously without any kind of contract that becomes very difficult. Though I can imagine there might be something, because she is obviously a shareholder as well from that angle.
Yeah, absolutely. So restrictive covenants are, really hard to enforce, really tricky area, aren't they? But I think one sensible way to approach it is to have another set of restrictive covenants in a separate document, which here could be a shareholders agreement between Mike and Caroline. And that's quite nice because it's separate to the employment angle. So courts will look at that differently. So there is a view that actually they still need to only go so far as to protect legitimate business interests, but actually this is a private agreement between two shareholder members, and it's not necessarily to do with your employment, which is how you make ends meet. So providing for restrictive covenants in a separate contractual document such as a shareholders agreement would have been a really nice approach on this one.
Yeah, and I think it's always important to remember the two different relationships there, and sometimes again in these kind of relationships get blurred between the employment relationship and the directorship, and they can exist separately and have different obligations and responsibilities.
Yeah, and focusing on that competition point, I'm sure if we had a commercial lawyer online with us as well, they would be saying, well, why hadn't the business been sewing up some of those supply deals as well, which may have actually put the shackles on Caroline to some extent in terms of setting up her business as she has. So Tom, if we can go back to you in terms of the company documentation or lack thereof, how is that contributing to issues that we've got at the moment?
It's an interesting way of phrasing it. It's contributing very negatively. It's a really common situation. I mean, this is slightly interesting in that, he's gone and got some legal advice from a friend. I'm sure that happens all the time. So he's gone to the step of setting up a company, and often we see clients do that and they think, well, actually, I've thought about this. I should probably have a company. I've set one up. Isn't that it? That's great. That's going to work. But actually, it's putting in place some thought around that company structure, and the governance of that structure is where a lot of that real value comes from in setting up a company as a structure. So here we have a company incorporated with model articles, which are the standard default articles. If you do nothing else, those will be the rules of the company which are assigned to it, and they really aren't suitable for a lot of cases, particularly with family companies and when you've got shareholder directors. So things like simple decision making, there are provisions in there which prevent directors from voting or counting in quorum for directors meetings. But where you have shareholder directors, it just doesn't make sense to have that restriction. So model articles, not ideal. And a lack of a shareholders agreement, again, the main issue here is that we have a 50-50% deadlock. So we have two directors at board level, two shareholders holding the same class of shares at shareholder level, which means if there is any dispute making directors' decisions day to day, what they're doing, who they're selling to, or at shareholder level, they are in deadlock and there is no dispute mechanism in there, or that's been discussed to get out of that. So they're in a position where the company can just be deadlocked, and there is no good way to get out of it.
We've actually had a couple of questions on the same theme, if we can do at this point, which is with Caroline being a director in the company, has she not just breached fiduciary duties towards the company by setting up in competition? Is that something, Tom, that you could comment on?
Sure. So directors will have duties which they owe to the company, and those are statutory duties in the Companies Act, and things like acting in the best interest of the company, acting fairly. By still being a director on the board of Mike's Veg Boxes, she continues to owe those duties to that company. So by setting up a competing business and pulling away or poaching suppliers, there is a real risk there that she is breaching her director's duties owed to Mike's Veg Boxes. There are ways around that. You might be able to ratify those sorts of actions in certain situations. If Mike says, actually, that's fine, we can agree that we'll divvy this up. But if you haven't agreed any of that in any contractual documentation, it's a tricky situation.
And I think it's a fair point to say in my experience, and Katherine can jump in if she is or not, there's actually normally many different strands of claim that people can bring against each other in these situations. And normally it seems to be left to the family laws in this situation to kind of bring all those strands together. And maybe not start a separate line of litigation, and it's something which Rebecca might comment on as well, in terms of the employment side of things.
Yeah, I was going to make a comment in relation to that. Wasn't quite sure at the appropriate stage to do it, but I'll do it now, because of course there are remedies available in those situations, but often they are slow and costly. And if there are competing or parallel proceedings in relation to family matters, then this competitive business perhaps was not such a good idea for to do, because it to some extent maybe preempts what the future outcomes may be for this couple. Businesses stand to be shared. She started a new business. She showed that she can do that. She perhaps presumed that she's going to be very successful at it. And so, to some extent, in taking that step, she may have preempted, whether intentionally or not, a view on her earning capacity moving forwards, her resources, those sorts of things. Yeah.
Yeah, and it's something the family courts would take into account in terms of her conduct. So any drop in the value in Mike's Veg Box, is something which the court would certainly, focus on as well as a prime example of conduct. It's normally very difficult, for the courts to take it on board. Yeah,
and she's reduced an asset she might have shared the value of.
Of course, yeah. Okay.
Yeah.
Have you got anything else to add, Tom, at this point, or should we go on to Katherine?
It might be worth just very quickly touching on the point around the separation between being an employed director and a director at Companies House. So the two aren't quite the same. So in this situation, we've had a termination of directorship, so employment, but actually Caroline is still appointed as a statutory director at Companies House. And that is something we have come across many times, and the problem is that it's very difficult then to remove Caroline as a statutory director. There are processes you can go down initiated by shareholders, but again, we're in a shareholder deadlock. So a method you could use to resolve that is to say in a shareholders agreement, for example, actually, if you are terminated, then you must also resign as a director from these companies. Or equally in the employment documents, if you're terminated as an employee for whatever reason, you must also resign as a director at Companies House from the company.
And we're sorely lacking that down to documentation and provisions in this case. Okay, Katherine, do you want to comment on what you're seeing from the family law perspective?
Yeah. So, clearly, if either Mike or Caroline were to arrive on our doorstep, a big issue here is the business and how the family courts will deal with this business when we think about, sharing the matrimonial assets. And one of the first things the court will have to determine, or we'll have to give some thought to, is what part of this business or these businesses forms marital assets, because they can be treated differently than other classes of assets, such as non-marital assets or contributions received at the beginning of the marriage. So there's lots of different strands that we probably want to have a think about here, including, for example, the fact that a proportion of that business is there as a consequence of gifts received by Mike well before the couple even met one another. So he may well have an approach to this which is broadly along the lines, well, that's mine, it's come from my side of the family, why should you share? Notwithstanding Caroline's status as 50% shareholder, we should have some recognition of the source of the asset and those sorts of things, and that has some merit. Although, of course, it was received, this is a longer marriage, and it's been very much shared, and it's been very much a joint venture moving forward. So we'd have a think about those sorts of things, and it might be treated very differently if it were a short marriage, of course. We might have a look also at where the wealth has come from one side only. Are we going to start looking at needs moving forwards more than sharing? Both parties will probably have a different view over that. Needs a somewhat elastic approach. So it would be that sort of ongoing balance between looking at these parties' needs and the principle of sharing the marital bequest. We would have been helped with that, of course. It's already been mentioned in this discussion, if there had been a premarital agreement, prenup, because a prenup, more than anything else, could have drawn a line in the sand and attributed a value at the start of the marriage to assets that Mike, in this case, was bringing in, and we wouldn't be looking at things historically and trying to look backwards and attribute values at the start of the marriage. So a prenup would always be very helpful, not only to have principles agreed when everybody's getting on with each other about how you're going to deal with business assets if things don't pan out, but it can also be really helpful in just establishing a value for a business at the start of the relationship. And it's much more difficult to argue about that later if it's actually written down in black and white. That's a sort of an improvement point. Would have been better if, and probably better for both, in fact, because it just reduces the argument, reduces the acrimony. So that's one point I suppose we'd have to think about. And the courts, of course, in terms of what they can do, if they needed to, they could order a sale of the business. Very, very rare, because of course nobody wants to do that, and they'll really seek to try not to interfere with it if at all possible. So it's all about trying to secure this for everybody's benefit, for wider family members here who are involved in this business. It's very likely that actually Mike and Caroline want that business to sustain and continue in one way or another, for the benefit of their children moving forwards. So if we can, we prefer not to sell, we prefer not to interfere, but there's got to be some sharing of the value. And then again, looking at value, we'd start thinking about getting experts in a fairly early stage probably to have a look at this business and attribute a valuation to it. And as I say, possibly look at the impact of Caroline's competitive business on values too. So quite a bit to have a look at there. Great exam indeed. Question, whoever drafted it, Andy.
I don't take all the credit. Okay, Ellie, let's bring you in at this point. So we've got Mike and Brian. They've inherited or been gifted some land from their father's estate. What points do you think need to be looked at?
Thanks, Andy. So I think there's quite, as if Mike doesn't have enough to deal with already with the breakdown of his marriage and his business issues. His father's estate and his father's death are going to raise some other issues that he needs to have a think about as well. So you mentioned the gift that Mike and Brian originally received, the 100 acres each. Now, that was a long time ago now. They were 18, now in their 50s. So provided that their father didn't retain an interest in that land that he gave to them, that should be well off his 7-year clock for inheritance tax purposes. So it shouldn't play into his death estate now he's died. Now, one of the issues they will need to have a look at is whether father retained an interest in any way in that land. Did he use it? Did he benefit from it in any way? Because if he did, they'll have to have a think about whether there's any reservation of benefit there for inheritance tax purposes, and if so, need to declare that as part of the administration of his estate. And they'll need to think about that administration generally. If they're executors, which is quite a usual appointment, is mum and dad appoint children as executors, they'll actually need to deal with the administration of dad's estate. So things like obtaining valuations for assets, submitting inheritance tax accounts, looking at what tax reliefs might be available. There's still some farmland in dad's estate, so is there any relief that they can claim there? So quite a bit of complexity, just to make sure they're capturing the reliefs they can, administering the estate properly and at the right values. There's also mention of Mike and Brian's mum needing some support going forward, and so they'll have to have a look at how she's due to inherit. It sounds like there's a will in place if they're intending on inheriting the 100 acres. So we'd usually expect there to be a gift to a surviving spouse in there, so either an absolute gift or a life interest. But it's probably a matter of a family decision of looking to mum and saying, well, okay, has she got enough to live on? Is she well provided for here? What assets does she have of her own?
Sure.
And looking at maybe whether she needs to do any estate planning as well. If she's got plenty, more than she needs, is it time for her to start looking at some gifting potentially? From Mike and Brian's perspective, certainly, the partnership seems to have done quite well. Mike's veg boxes were doing well until Caroline scuppered that with her competition. But from their perspective, they may look to dad's estate and look at what they're due to inherit and say, well, actually, maybe we don't need all of this. And they could look at something like a deed of variation. So they'd have 2 years from dad's death to have a look at that. And they could maybe look at passing assets down a generation, perhaps into a trust structure for some protection there for the children, particularly relevant if Simon's keen on being involved in the business itself.
Yeah. Are they handcuffed to some extent, though, if Brian is lacking capacity at the moment? Is it too late?
Yeah, so that's a real concern. So it looks like he's struggling to make decisions in relation to the partnership. Now, that doesn't mean that his capacity is a write-off. Capacity is assessed on a decision-by-decision basis. So just because he can't make decisions maybe on the big picture business things doesn't mean he can't make decisions about other things, such as a deed of variation or his own assets. But it's certainly pointing in the direction of he may be struggling on that count. So if we look at a couple of different things where he might need to make decisions, say if he is appointed as an executor and that's not something he can undertake due to capacity, if he's got a property and financial affairs lasting power of attorney in place, his attorney could act on his behalf in that role. Or, they may take the view of that's not really something they want to do and actually Mike can do this alone. If he doesn't have a power of attorney in place, obviously that's just, a bit of a nightmare. And going forward, if his capacity was on the decline, the family would have to look at maybe making a deputyship application just so they can get some control over his financial affairs, which is obviously particularly relevant given he's a partner in the farming partnership. So there's quite a lot to think about there in relation to Brian's mental capacity. And certainly, even if he has a power of attorney, the deed of variation would be off the table if he didn't have capacity to understand what that document did and the repercussions of it.
Sure. Okay, so it's clear there's quite a mess at the moment in terms of their situation. So what the lawyer would normally say is, yes, you should go and take some advice. It's really clear that Mike and Brian's family as well and Caroline do need to take some legal advice, but maybe the focus now should be on ways that they can actually find a route through some of this conflict. And so, Katherine, what sort of approach could they be looking at to try and reopen those lines of communication?
Yeah, I think actually probably really important to think about different ways of sorting things out, particularly where there are a sort of wide range of people whose needs have to be met. So in this scenario, you've got Mike and Caroline who've been successfully running a business together, and in all likelihood, they do want to preserve that one way or another for the family, albeit separated family moving forwards, and their children. You've got Mike's father, who's recently deceased in the estate there, and probably some wealth protection issues. And inheritances are always, within family proceedings, certainly my experience, is incredibly emotionally charged assets, quite understandably. And this has come right at the end of the marriage, but it's not fallen in, so to speak, in any right now, but it's inevitably going to form part of the discussions. You've got Simon engaged to Jess, so there's going to be some potential wealth protection issues there in terms of prenups, or how they deal with any inheritances received, and indeed how that links in with any assets that Mike and Caroline retain post-separation, post-divorce negotiations. How are they going to both is it important to them both to protect those assets for their adult children moving forwards as well, as opposed to any concern about perhaps new partners in the future, those sorts of things. So where there are lots of competing needs, and in any event, of course, it is always going to be better for everybody to try and engage in discussion and negotiation, rather than put the boxing gloves on and end up down that path of litigation, that rabbit hole that takes months, if not years, to sort out, and obviously comes with huge financial and emotional burdens for both parties involved, and rarely achieves quite the level of fairness that perhaps they each seek in their own eyes. Fairness at court is not necessarily fairness of either party. They'll have different perceptions of what fairness is. So family proceedings really are very much geared towards appropriate dispute resolution. We used to call it alternative dispute resolution. I think appropriate is far better way of describing it. And obviously, I'm an accredited mediator, and mediation is something that they would be well advised, I think, to have a think about. It doesn't mean that they don't investigate the assets. It doesn't mean that they don't have to attribute valuations to their assets and get some up-to-date property valuations of this property on the farmland as well, which had to have updated values. It's a similar exercise still in saying, well, in order to discuss what we do, we've still got to establish what we've got in the pot. That can be an exercise that is carried out within the mediation process. Sometimes people feel that mediating is a way to avoid that, and it really isn't. It can be used to effect that process. In fact, before you then move on to discussions about, well, actually, Mike, what's important to you? Caroline, what's important to you? What are your future plans? You've set up this business. Is that actually where you see it moving forwards? Perhaps we can, factor that into your negotiations. So mediation definitely would be something that this couple would be encouraged to think about.
And I think mediation, Katherine, is something which people in the business world know a lot about. And there's different models of mediation, isn't there? Our family, I'm a mediator as well. And when we mediate, normally we're in a room with the couple. Yeah. But the civil model of mediation, which people from the business world might be more know better, is the one where you're shuttling between rooms.
Absolutely.
That's the same with arbitration as well. You can arbitrate family law cases.
And actually I've mediated, and as a mediator and also as a lawyer in family proceedings where it is viewed as a one-day mediation, and we have shuttled it, and we have had legal advisors involved as well. So there are different forms of mediation which will suit different couples, and it really is very much a process that they can be guided through, and it can be very, very helpful, and sometimes helpful if there is actually litigation already in place, because the pressure of hearings coming up can really sort of compel people to properly engage if it's, as you set out, sort of a full day. It's almost like people listening to this may be more used to a sort of commercial model of mediation. Everybody can be engaged if they feel, well, if we can't agree this, we've got 5 days in court with an outcome that none of us are going to really want or have very much control over. But there are other methods as well to try and shortcut the process. I call it the sort of privatization almost of family law. We have negotiation hearings as part of the court process. We can have what we call private financial dispute resolution hearings, where we can have a whole day set aside and the parties choose effectively a judge who will be a barrister, and you have a guaranteed day in front of that judge, and they can give you their views about outcomes, and they can actually be very effective and advantageous, because you don't run the risk, as practitioners will be aware of, of being bumped off your court list at very short notice and all geared up and ready for a negotiation. It doesn't happen for no party's fault, particularly just because of the pressure that courts are under. So private FDRs, arbitration, all of these avenues are available to people to try and find alternative ways of sorting things out and negotiating. I think being very open to roundtable meetings and talking about things. People shouldn't see law as solely being litigation. There can be a lot more creative than that, in fact. And
that's something which one of our guests has mentioned, the collaborative approach. Katherine and I are both collaborative lawyers, and that's something that we would certainly be discussing in this context, and it's a fantastic approach. We haven't got time to look at it in more detail now, but with the great benefit of bringing people with expertise, lots of people who will be on this call, into those meetings to work together. Two solicitors, the husband and wife and experts all working together to find a fair outcome which works for all, which I think is really a really worthwhile approach, and one which certainly needs consideration. Can I just jump to you, Rebecca? I think mediation, it pops up in employment quite a lot, doesn't it?
Yes, it does. Yeah. So we have the Acas free mediation service, which every claimant is obliged to use and go to before they even bring a claim. And the whole ethos is to try and resolve things prior to getting to the point of litigation. In reality, employment's got very tight time frames. So you have to go within 3 months of an incident or dismissal. Mediation does extend the Acas service, but usually in these kinds of situations, employment does tend to take a back seat. The employment tribunals would only be interested in the employment dispute, which tends to be a smaller aspect of a bigger issue. But it's something that we often have to work in parallel with other family lawyers, etc., to make sure that it's not forgotten about, but that you get the best result of dealing with both.
Sure. Right. Okay. So let's move on to Amber and Simon. So the next generation. So although there's some conflict there in terms of Simon wanting, a slice of the pie, and Amber being worried about not being engaged in the family in the same way as her brother. Ellie, if I come to you first of all, what from a private client perspective, what should this family be thinking about now with these two children in play? You've already mentioned the idea about potentially Mike and Brian's dad's money skipping a generation, and maybe that might incentivize Simon and Amber, and that's not something I've actually thought about. But what else should they be thinking about?
I think really the key thing is for Mike to think about his succession and how that's going to work in relation to the family as a whole. So particularly relevant, seeing as he's separating, getting divorced. He needs to make sure his will is up to date, or even indeed that he has a will if he hasn't got one already. If he does have one in place, the fact he's separated doesn't particularly affect it until the decree absolute comes through. So he needs to really think about what's in that will and actually making some changes on the assumption that he doesn't want Caroline to benefit. And I think he'd really want to think about that next generation and how he is going to benefit them, what's going to happen with his partnership interest, what's going to happen with his with the shares in the company, and how to maintain that balance between his two children, given the fact they might have different career paths. I think probably the advice we would give him is something nice and flexible in place to make sure that things can be adapted to in future and tweaks made around who gets what to try and achieve that fairness, because that fairness is not always necessarily equality, but it's about achieving what's right for the whole family. And I think it's really key that I think hopefully this session probably shows that when we're advising our family business clients, we do encourage them to think wider than just the discipline of the lawyer they happen to be talking to at the time. So we'd want them to think about the family business as a whole, who's involved in it, who's the succession, who's employed, who's not included in the business and doesn't want to be but may have a different career path, and how they may have different drivers in life and how those impact the business. So I think we'd really want him to think wider than just I need a will, or I need to take advice from all of these lawyers, and actually what's right for the family, what's the family's future looking like, what does succession look like, and actually have those conversations with his children, just to make sure there's lots of transparency there and that there's no surprises for anybody should something happen to Mike. Obviously things like tax reliefs, it's a given we'd want to have a look at those and maybe see if there was anything, what assets were going to qualify, if there was any tweaks that needed to be made to make sure that those reliefs were obtained. And looking at Brian's incapacity, we'd want to make sure that Mike's got powers of attorney in place as well, so his children aren't left with a bit of a mess should he lose capacity. And then ideally we'd look to the next generation as well. Simon's engaged, going to be getting married. If he wants to be incentivized, if he receives shares in the business, he needs a will himself. His future marriage would actually revoke that will automatically, but they can be drafted in contemplation of a marriage. So he'd have to make sure that was done so that will remain in place after he'd married. Amber's under 18, so she can't have a will yet. But if the plan is for her to inherit assets, we'd encourage her to look at that as soon as she turned 18. Not a very interesting thing to do for your 18th birthday, but a very sensible one nonetheless. So again, lots to think about for the next generation as well.
Great. Katherine?
Yeah, well, I mean, I think what Ellie says is so important, which is really and actually is the interesting bit of the job we do sometimes, isn't it? It's actually understanding your client's business and also understanding what they seek to achieve rather than making any presumptions about what they seek to achieve. So, sort of looking at it more holistically ideally. So, actually on a divorce, the reality is the courts aren't going to be the court's priority. If they were making decisions and they were looking at an asset, a business, the court's priority isn't necessarily going to be to preserve that asset for future generations. The court's priority will be what do we have to share and how do we share it in order to have a fair outcome that meets both parties' needs after a long marriage. So that the children, the adult children, won't be necessarily, their needs won't actually be the priority for any family court dealing with this. Amber's not quite an adult, so there'll be some element of provision likely to be made from the assets somewhere if she has tertiary education costs or some level of child maintenance still through her what I like to term fledgling years, which seem to last for a long time nowadays. But so there'll be some element which will concern Amber, but otherwise the courts, if they were imposing decisions, won't be as creative as this couple could be, albeit separating couple, if they were able to come to their own decisions and negotiate their own agreement. And it might be that they're able to reach some level of consensus that actually they want that maybe share the business in a way that perhaps might retains a proportion of it, but there's documentation in place which ensures it passes down to the next generation or can't be attacked with a future partner or future marriage, those sorts of things. So I think that it would be very important to have a think about what they both seek to achieve or could be persuaded to seek to achieve ultimately that a court might not have the ability or desire to do more complex outcomes. Yeah,
sure. Tom, I'm mindful of time, everyone. We are almost at the end, but we've got a few things just to pick up. But Tom, absent any agreement being reached by Caroline and Mike, or a decision being made by the court, is there anything Mike's Fedge Boxes can do for Simon at the moment in terms of shareholdings or incentivization, for example?
It's a really horrible question because it's such a mess already. So I suppose having these model articles and no shareholders agreement. So in terms of the shareholding and transferring those shares away, so to Simon or whoever, in the model articles there is no right of first refusal or preemption rights on those share transfers. So your starting position is actually Caroline could purport to transfer those shares to whoever she wanted. There are then issues around directors needing to approve that transfer, and it gets very messy again. But I think the important point here is that if everybody had sat down or thought about what they wanted to achieve, it would be very simple to provide, for example, that actually we will just say, Mike setting up the business, bringing on Caroline, there will be no transfer of shares without Mike's consent. That's really simple, and that really protects the shareholding in the business then. And then there is a huge amount of flexibility as to what you want to do with those shares. So should Simon get a different class of shares? Should they be non-voting? Should they be just economic rights? Should they be linked to his employment? So is he going to work in the business? And actually, if he gives it a go and decides he can't be bothered and he still wants to seek the financial rewards, well, actually, if you terminate as an employee, you have to give your shares back. Thank you very much. So there's lots of ways you can approach it, a huge amount of flexibility. It's just having those conversations at the outset to make it work.
There are perhaps lessons to be learned here, aren't there, from Mike and Caroline and the difficulties perhaps they're now facing. That Simon and Jess can take, and obviously a nuptial agreement would be really helpful, because they could agree now, for example, if Simon is going to become involved in this business, which has been in the family for generations now, he would say, in terms of where it's come from, he might like to set out in a nuptial agreement that the intention always is that proportion is a proportion he receives now is going to be retained by him, to preserve it as a family, a generation asset on that side of the family moving forwards. So I think there are lessons that can be learned that here, and articles of association sometimes can deal with share transfers, etc. Who can receive those share transfers? Should it be limited to people working in the business rather than people who are no longer working in the business? Those sorts of things. So it might be that Simon and Jess can make a better job of this.
Agreed. Rebecca, from your perspective?
Yeah, I think it's, again, learning lessons of it would help if they had clear job roles, so Simon knew what his role was in the business and that was all documented and contracts in place, and that kind of succession planning can be put in place more easily then if you have a clear job role and you're at this level and you can take over the business or whatever in the longer term. And obviously, if Jess has got a clear role as well and a contract in place, it makes it easier if things then fall apart between them. They could continue on in their respective roles professionally, etc., or depart knowing what each is entitled to. In terms of incentivization, it's quite hard, and we had a few questions around whether someone had authority to even dismiss Caroline. Well, this it does become a bit of a grey area, because from an employment perspective, it's quite easy to dismiss someone. You don't need a director level authority necessarily, but I'm sure Tom will say there's all sorts of potential risks around directors acting outside their authority in taking such decisions. So there's lots of things you could do to incentivize Simon, like bonuses, giving him a promotion, things like that. But whether you'll actually be able to get that done without Caroline on board is obviously a question mark.
And that is the difficulty. Okay, well, we are at the end now, so I'm just going to hopefully share the right screen again, if we can see that. So up on screen, a big thank you for joining us. You've got our details here. Please take a screenshot or a picture if you've got any further questions for us or would like to link in with us. The QR codes, if you scan those, they should take you straight through to our LinkedIn pages. Tom and Rebecca's are on the next slide, so I'll move over to that in a minute. But we would love to hear from you further. So I think in terms of summary of what I think I've heard today, and hopefully you've all, reached the same viewpoint, is that it's impossible to avoid conflict in any business, let alone a family business. And I think prevention is better than cure. I think we've shown that Mike and Caroline, if they'd had the right documentation in place, they would be in less of a sticky position they are, whether that is prenups or shareholders agreements or employment contracts or whatever it might be. But there are ways that we can assist our clients when they're going through that level of conflict and journey to support them in it, albeit it's more expensive and more lengthy in time scale if you're basically having to retrospectively try to fix a few things. And that's the plug really from all of us on the call today, and also thinking about other areas of practice we have at Mills Reeve. We are a full service law firm. We've got great sector specialties, whether it's food and agri, automotive, private wealth, health, education. We could put a team together to undertake due diligence for your business or your clients' businesses or family, and just see where areas of risk are and ways that we can reduce that risk in the future. So a big thank you to everyone. A final congratulations to Katherine and Ellie, who actually were made partners this month. Very well deserved, and congratulations from me and the rest of the firm. I'm just going to say it from everyone else as well. Just so there's Rebecca and Thomas's details as well. I think we've answered some of those questions. We've got one last one. Isn't it a legal requirement for employers to issue contracts to all employees? Rebecca?
Yes, it is, but technically you can create an employment relationship verbally. So there isn't you can enter into an employment relationship without a contract in place, but there is a statute that requires you to issue them with a written contract, have very specific written terms that you are required to include, and there is a penalty if you don't, but the penalty is a few weeks pay, so it's not necessarily a significant issue. So it's not unusual that people don't enter into it, and you can create a verbal agreement and an employment relationship. So yes, you're right, but doesn't always happen.
Okay, perfect. All right, I think that brings us to a close. As I said at the start of the webinar, we do have a feedback form. Please do fill it out. We are running a series of webinars, and delighted to continue them and cover topics which you're interested in. So thank you for attendance. Go and enjoy the sunshine. I've heard there's a feast in the freezer for me downstairs, the joy of working at home when your kids have just come back from school. And I'll bid you a good afternoon and thank you again.